Today we begin the resentencing hearing in the Menendez brothers case. What's important to know is that we always anticipated, as far as the district attorney's office goes, that we would be here for a resentencing hearing, because there was two ways to get here. The first way is that the court initiated its own motion for a resentencing hearing, and we have said all along that we were prepared to go forward with that court-initiated motion. The prior district attorney had initiated his own motion. We opposed that motion because we basically said that the prior district attorney had left out the majority of the key facts in making his motion, and we wanted those key facts before the court. But either way, we anticipated having a resentencing hearing starting today. Now, with respect to resentencing, what you have to appreciate is what that concept actually means. A resentencing statute doesn't exist in most states in the United States, because the idea is that if you're going to challenge your conviction and your sentence, there are plenty of different types of appeals that are available to the typical defendant to do that challenge. A defendant can appeal their sentence directly, as was done in this case. The Menendez brothers took their sentence and their conviction to the California Court of Appeals, and it denied that appeal. They then took it to the California Supreme Court, and it denied that appeal. Then you can go a second route, and you can do a habeas petition. The Menendez brothers availed themselves of that opportunity, and the California Supreme Court again denied their habeas petition. Then they went the federal court route, and they filed a habeas petition with the U.S. District Court, which denied their habeas petition on the federal grounds, and they took that up to the appellate court, the Ninth Circuit Court of Appeals, and it too denied their Court of Appeals petition. So 5 different courts evaluating the Menendez conviction and evaluating the Menendez sentence have turned those appeals down. But California has this additional statute called resentencing. And the idea was that resentencing was not designed to let every murderer who's had their convictions affirmed by 5 different courts of appeals to let them out. That the resentencing statute said that in those unusual cases where a defendant has met the criteria for resentencing, including accepting full responsibility for the range of their criminal conduct, including demonstrating rehabilitation within the prison system in which they exist, assuming that also that when they've been in prison, that they didn't commit certain violations showing that they were not ready to be released, that in those fairly rare situations that a court now has the power to actually do something that hasn't been done in this case for over 30 years, which is overturn effectively the jury's conviction and sentence that was for a first-degree murder conviction of Jose Menendez with special circumstances, a first-degree murder conviction of Kitty Menendez with special circumstances, a sentence that then was life without the possibility of parole, which has been the sentence for over 30 years. So now in this resentencing procedure, they are asking the court to go ahead and effectively overturn that sentence and turn a life without the possibility of parole sentence into a life with the possibility of parole. We have said with respect to resentencing that our position is not no, or it's not never, it's not yet. And the reason we said that is that the Menendez brothers have failed to come clean with the full extent of their criminal conduct, their cover-up, their lies, and their deceit over the past 30 years. As we've explained, the Menendez brothers persist for 30 years, as recently as 2024, in insisting that the reason that they killed their parents, and when I say their parents, I mean their mother and their father, is not because of the sexual abuse. When they testified at trial, they were asked that question specifically. Was sexual abuse the reason that you killed your mother and their father? The answer was no. They said the reason they killed their mother and their father was that they believed on the night of August 20th, 1989, their mother and their father were going to kill them, so they had to kill their mother and their father first. That has always been their defense, the self-defense defense. And we have shown through an extensive analysis of 50,000 pages of trial transcripts over 2 trials, of hundreds of hours of videotape testimony, of a review of prison files, interviews with the Menendez family members that I have personally had, a review of also prior prosecutors and law enforcement, that self-defense defense is a lie. It was a lie back in the 1990s when they presented it at trial and the jury rejected it, and it is a lie today. The Menendez brothers engaged in a deliberate, premeditated killing of their parents based on buying shotguns 2 days before the killings, going ahead and having a pre-planned alibi for the night that they were going to kill their parents, killing their parents in a methodical way to make it look like a mafia hit by shooting their father through the back of his head. Their mother, as she lay bleeding on the ground, reloading a shotgun and shooting her point-blank range through her cheek, shooting the parents afterwards through the kneecaps to make it staged like a mafia hit, and then running out to the police after they called the 911, shouting that someone killed our parents and that the Menendez brothers were going to find that person and torture them. All a lie, as was the self-defense defense. They even added additional lies when Lyle Menendez tried to get one of his girlfriends to say that the girlfriend had been violently raped by the father. A total lie. Lyle Menendez and Erik Menendez got another of Lyle Menendez's girlfriends to say that the mother had tried to poison them. Again, another lie. And the Menendez brothers have never come fully clean with all the lies, cover-up, deceit that they have told for the past 30 years. When and if they do, and they do it sincerely and unequivocally, to the satisfaction not just of the district attorney, but ultimately the court that is going to hear this type of testimony, then the Menendezes will be ready for resentencing. Then the Menendezes will show full rehabilitation. Then the Menendezes will no longer constitute a risk of danger to society. And we started with this analysis that we presented, but most recently the analysis was corroborated by 2 comprehensive risk assessments done by board-certified psychologists for the Board of Parole that was released about a month and a half ago. And what these comprehensive risk assessments essentially said is that the Menendez brothers had been raised in risk level from low to moderate risk of violence should they be released. And what they focused on was not just the rehabilitative efforts, which the psychologists all noted and commended the Menendez brothers for their different and extensive rehabilitative efforts. But what they were concerned about that posed this risk of violence was the deceit that the Menendez brothers had engaged in while their resentencing motion was actually in play since October 2024. Lyle Menendez had engaged in deceit by violating the rules and bringing a cell phone into the prison. Just when you would think you would be on your best behavior, as a court is going to consider your resentencing motion, Lyle Menendez smuggles a cell phone into the facility. And why is that important? Well, a cell phone is not a monitored device by the prison. Every single communication that you have, if you want to speak on a phone or a tablet, there's actually a recording saying it's being monitored by the prison, but not if you bring in a burner cell phone, which is exactly what he did, and he got caught. Same thing with Erik Menendez. Another, in January of 2025, he goes ahead and violates the prison's rules and brings in a cell phone as well. He also admits to engaging in the purchasing of drugs with other inmates in years before, helping inmates engage in tax fraud. Again, what the psychologist looking at this said is that this shows that notwithstanding those rehabilitative efforts, their risk level is no longer low. It is moderate. There's a moderate risk of violence because if the Menendezes are released, they're going to head and not be in a highly structured setting like a prison. And if they can't follow the rules in prison, then the confidence level of these psychologists have dropped on whether or not they will now pose a risk of violence in society. So the court today will now consider evidence. The Menendez brothers' counsel will most likely present a series of witnesses to try and provide additional evidence to the court. The prosecution has been doing just that, providing the court with as many facts in order for the court to make this final determination on whether or not the Menendezes have been rehabilitated and constitute that risk of danger to society, that if they don't constitute it, they can then have a resentencing, and if they do constitute it, then the resentencing will result in not being effectively resentenced. Because let me leave you with this, what the three options are for the court to do in this case. The court had the obligation, once it made a finding, essentially, that it was going to go forward on its own motion and the people's motion to have the resentencing hearing itself. But that doesn't mean that the court is obligated at the end of it to actually resentence the Menendez brothers. The court is not allowed to increase the sentence to the Menendez brothers, but it is under no obligation to actually change the sentence for the Menendez brothers. So that is one option, that after hearing all the evidence, the court decides not to change the sentence. The second option is that the court does resentence the Menendez brothers to a sentence of life with the possibility of parole. At that point, the Menendez brothers will then go to the parole board. If the parole board were to grant parole, or even if they were to deny parole, it would end up with Governor Newsom, and he makes the final determination, he and he alone, on whether or not the Menendez brothers will ever get out on parole. But there is a third option for the court to engage in today. Because when people talk about the sentence, the Menendez brothers sentence, there's actually two sentences at play. One sentence was the sentence for the killing of Jose Menendez. As a first-degree murder violation with special circumstances, the sentence for the killing of Jose Menendez was life without the possibility of parole. But the second count was dealing with Kitty Menendez, a separate sentence. And that sentence also was life without the possibility of parole for the sentence of Kitty Menendez. So there is a possibility where a court could resentence the Menendez brothers based on the Jose Menendez killing and murder, but choose and then change that sentence from life without the possibility of parole to life with the possibility of parole. But separately, when considering the sentence dealing with Kitty Menendez, for factors that the court can consider unique to the sentence of Kitty Menendez, the court can decide not to change that sentence. So even though there will effectively have been a resentencing for Jose Menendez, there will not be one for Kitty Menendez, and the Menendez sentence overall will be life without the possibility of parole were that circumstance to happen. So again, we're going to have this resentencing hearing over the next several days, 2 days. I don't know if the judge will rule at the very end of it. He can decide to rule in open court at the end of the hearing. He can decide to take it under submission. He might want to write an opinion about what his thoughts are. He might want to hold another court hearing and announce them from the bench. We don't know one way or the other. That will be up to the court. So that is the overview of what was going to happen today and tomorrow. I'm happy to take any questions.
You sound like you are almost recommending that the judge splits these cases. You sound like you're leaning towards that as an option. Is that true?
It is an option. What I wanted to do today is flag all the options that the court has.
Is there one that you prefer?
Well, again, what we have said is that the Menendez brothers are not ready for resentencing in this hearing. That because they have not engaged in the full panoply of admissions of their criminal conduct, that they're not ready for resentencing on either one of the convictions.
You would be comfortable with a resentencing on the Jose Menendez charge, but not on the Kitty?
No, just the opposite. No, the option that we have addressed in our papers and will be addressing in court is actually the first option. The first option being no resentencing at all. That you can have the resentencing hearing, but the Menendez brothers have not shown the true and complete insight into their actions. The comprehensive risk assessments establish them at a moderate level. And if and when they get back to the low level of risk, if and when they admit to the full range of their criminal conduct, at that point, we're saying, they might be in the position for a full resentencing, but we don't believe that is today.
You talk about the risk assessment. What is your greatest concern if they were released, that they could possibly murder again?
The risk is a risk assessment for violence, whether it's murder or other types of violence. It is the concern that the Board of Parole's board-certified psychologists have in raising that risk assessment level from low to moderate. They're basically saying that while the Menendez brothers have been in prison, it's a highly structured environment. And if they're willing to break the rules in this highly structured environment, the confidence level that they're willing to comply with the rules, including rules that say effectively you can't engage in violent acts or other types of acts. These are the laws in our society. They have lost some level of confidence in, and they've made it known, again, to the Board of Parole, to the governor, and in this case, to the court itself.
Now, most of us are rule breakers. Are you concerned that their level of rule breaking would rise to someone getting hurt or killed?
It's not my concern. It's the expert psychologists' concern in prison that have risen their risk level up to that moderate level. We've also added to it a whole range of lies that they have told for the last 30 years and have never come clean with, to again show that they have not fully accepted responsibility for all their criminal conduct, and in our minds not fully then rehabilitated and do constitute the risk for violence as well.
Can you talk about the conditions they're going to be in when they come out, though? Like, I'm just kind of curious if a lot of people, when they struggle and reoffend when they come out of prison, right, they come home with no resources, no money. They're going to come home to a family that supports them, a lot of money, presumably immediate job opportunities. Does any of that, in your mind, counterbalance the lying? Like, how do you play that out? I guess the other side of that equation, they're going to come home in a pretty beneficial situation, right?
So we look at the Menendez case not in isolation. There are literally dozens of criminal defendants every single month that make their pitch to my DA's office or DA's offices across the state and say, we want resentencing. And we have to be fair and treat these cases in a uniform way. So we're not going to give any special treatment just because the Menendezes, when they get out, might have additional resources that any other defendant might not have. The risk level is assessed both by the board-certified psychologists in connection with a review of the entire factual record to determine whether or not today, and I'm not talking in the future, but today, they justify resentencing, and we have said they don't today. Any other questions? Yes.
So the brothers are not expected to testify. We've been told it is possible that statements that they have written could be introduced on their behalf. If those statements do take accountability and sort of answer your questions, would that then force you to change direction when it comes to resentencing?
You know, what we have said is that the Menendez brothers unequivocally and sincerely accept full responsibility for all their actions and cover-ups, that we would reconsider our position. I'm not going to reconsider it in a vacuum. I'd certainly want to see exactly what they're saying, and as importantly, they have to convince the judge. Because while convincing the district attorney's office is certainly at some level important, the real important task is for them to convince the judge that they have unequivocally and sincerely come clean with all their criminal conduct. I don't know if a written statement by itself, it depends what it says, will go that far, but it's certainly something that we should consider, as should the court. Any one last question?
I have a quick question.
Yes.
What happened to the member of the Menudo that claimed the father molested him? What happened to the family?
I don't know that particular situation as to what happened with that individual. Again, when it deals with sexual abuse, what we have said is that our focus is actually on the self-defense defense, because that wasn't us saying that. That was actually the Menendez brothers themselves testifying to it at trial. Again, when asked that question, did you kill your parents? Did you murder your parents that night because of sexual abuse? The answer was no. They said the reason they did it was they thought their parents, their mother and their father, were going to kill them that night. So they had to kill them first. All right, thank you all very much. Appreciate it.